All right. Thank you, everyone, for joining us for this episode of the Immigration ABCs podcast. I am your host, Dustin Saldarriaga. I'm an immigration lawyer with Scott Legal PC in New York City. In a recent episode, we sat down with the founder of our firm, Ian Scott, to talk about changes to the U.S. immigration landscape in the last year since the re-election of Donald Trump. And in Ian's episode, we focused primarily on visa options focused on investment and entrepreneurship, including the E-2 visa and the EB-5 green card. Today, we're continuing this topic of looking at changes over the last 9 or 10 months by speaking with my colleague, Kelly LeGrand-Weiner, who is the managing partner of our firm. And we are going to be talking with Kelly about primarily student visas as well as extraordinary ability visas. And that would include the O-1 and the EB-1 visa options. Kelly, we recorded an earlier episode with Kelly a few months ago. So I'm not going to spend a whole lot of time going into Kelly's accomplishments. I will quickly just say that Kelly has extensive experience both in immigration law and at our firm. She's been at our firm since 2014. She's been practicing immigration law for well over a decade. And in that time, she really has seen the full spectrum of U.S. immigration cases. So she is a wonderful person to talk to about not only changes to the landscape, but what is actually happening on the ground and what's actually happening in individual cases and how that's changed both in the first Trump administration, the Biden administration, as well as the current administration. So Kelly, welcome back to the podcast. Thank you for taking time to be with us today.
Yes, thank you for having me.
So let's start off with a very general question. How would you characterize this administration's overall posture toward business immigration when compared to Donald Trump's first administration?
Yeah, so I think this approach is much more aggressive than the first term, really across the board, and has kind of a clear aim in limiting legal immigration.
And in terms of those limitations, there are many things the federal government can do. It can pass a law, it can change regulations, or it can issue executive orders coming right from the president himself. What has been the source of those limitations primarily? Is it changes to the law? Is it changes just in terms of policies, executive orders? Where are you seeing those changes come from?
So I think it's really a mix, right? It's a mix of, obviously there were many executive orders that came out really early on that were, quite aggressive, talked about wanting, enhanced vetting and border security. But there's also within that, with those executive orders, now we're starting to see more formal rulemaking start to come out as, more time has passed. But prior to that, there have been a lot of those quiet shifts in the adjudication standards and in internal guidance. For example, we're starting to see, issuance of notices to appear to H-1B workers who are on their grace periods. These are discretionary grace periods granted after their work ends that are authorized by the government. But because they're discretionary, the way this administration is approaching it is they're still sometimes issuing notices to appear in immigration court, essentially putting these people into removal proceedings. So that's a very aggressive change in which there has been no actual official announcement. This is just something we're starting to see on the ground. And it's by no means happening in every case, but it is starting to happen more and more and is obviously quite concerning. Previously, H-1B workers could feel quite comfortable that if they left their job or they were fired from their job, that there would be this discretionary grace period where they could kind of look for other employment or, make plans to depart the United States or change to another status. And now to have there be a risk that they be put into removal proceedings with no official changes announced anywhere, it's a very startling change to say the least. Just another change I want to flag that's very, kind of important is there was a freeze to a program that issued social security numbers to people who requested them on their forms. So people filing for work authorization, green cards, naturalization are able to check a box that says, yes, I would like to have a social security number issued to me, automatically. That program was frozen. Again, like there's maybe a couple minor news articles about it, but no official announcements on this change. And now people do not realize, well, I'm not actually going to get my social security number. I'll have to go to the social security office. No announcement about these types of things. And although they may seem small, they make a huge difference, obviously, to the people impacted.
So it's clear there are a number of moving pieces, very difficult to keep track of all of these changes. What if our listeners are wondering, well, how in the world do I try to keep up to speed or know where these hurdles and pitfalls are? And let's take the perspective of U.S. employers. What would be your advice to an employer in the U.S. that's looking to bring on a foreign worker in terms of how to make sure that they're aware of these changes?
Yeah, so I think, obviously, I think hiring an immigration attorney is more important now than ever. Having, counsel that is specific to immigration, because as so many of these trends are really emerging trends, the immigration bar, one of its strengths is really that it is very collegial and engages in a lot of information sharing. The American Immigration Lawyers Association in particular, provides a lot of kind of on the ground information as things start to come up and tracks these trends. So I do think it's very important to have counsel that is specialized in immigration right now, because many things that are happening, it's not always clear on its face what exactly does this mean. And because there's so many quiet shifts in policy without actual law changing, it can be easy to miss if you are not kind of really in this world. Also, advanced planning and just having backup plans, I think, is always important for U.S. employers, as well as kind of having a more rigorous intake for your applicants, just to understand, is there any criminal history? Are there any immigration violations from the past? Any prior visa denials? Things that in the past may have been either overlooked or not seen as major issues are now things that are being brought up.
Absolutely. And so just to give a glimpse into the life of an immigration lawyer in this administration, I'm not going to speak for you, Kelly, but I know that you do spend a lot of time reviewing regulations and policy memos. I would say I am probably spending at least 30 minutes a day just to get up to speed on not only what the official changes are, but also, as you mentioned, getting up to speed in terms of what other practitioners are seeing. And so that is the kind of thing that if you're not in this world, it is really difficult to replicate that. It is not a matter of signing up for news alerts. It really is a matter of constantly being in touch with dozens of other immigration lawyers and following what are they seeing in this type of application or at this specific consulate. So echoing that, I think is important. So I framed the last question in terms of employers. Would you say anything differently in terms of if we were speaking to an individual who's looking to get hired by a U.S. company? How would your guidance for them be any different, if at all, in this context?
Yeah, I think there is some overlap again in the sense that it's just really important to think back about, your immigration history in the United States. Was there ever a time, maybe you were, really, really young and, your family had some removal order, and you never really knew about it. Like it is important to really look at kind of your entire history in the United States. Similarly, if you had, a criminal issue and, it was expunged from your record or just never came up, these are the types of things that were really, as they kind of are digging more deeply into every single applicant. These are things that they're really looking at. And so you really want to consider, what is what is in my record, being as honest as possible, with your attorney so that they can help prepare you and you're not getting an unpleasant surprise where you're denied and it's, well, I had a criminal conviction, but I thought I didn't have to disclose it. And now they're aware of it and now it's caused an issue for your application. So I think, you have to assume that again, we're in an era of enhanced vetting. So that means they are digging more deeply into everything. And also, when you're considering coming to the US, that conversation needs to be had with every member who's coming with you, right? So maybe if you didn't have any issues, but your spouse had some issues, these are things that you want to be able to talk about. To avoid getting any unpleasant surprises when you're going for your, visa interview or applying for your change or extension of status.
So one of the most common pathways for someone to for a foreign national to pursue work in the U.S. is through the student route. They come here on an F-1 visa. They start working on OPT. They may get a job offer. And unfortunately, the F-1 visa, the student visa, has been a focal point in this administration. So, Kelly, would you be able to just take a big step back and maybe, in very broad strokes, provide an update on what steps the administration has taken that are really focused, targeted on F-1 students, and including OPT, including duration of status, including everything that was going on a few months ago in terms of threats to their status, threats to their visas. Could you just give us an update on where historically what's happened and then where things currently stand?
Sure. So, we've seen it's been in the news a lot. Obviously, there's been a lot of back and forth about F-1 visas. There's been particular schools that have been targeted. Obviously, Harvard has been in the news a lot. We've also seen, kind of students, having, visa revocations or even being taken into detention for, ostensibly kind of speech that the government is, unhappy with or doesn't agree with. And as a result of that, we've now seen a change to how and MJ visas are adjudicated. So if you're going to get an F visa now, you have to make all of your social media public, and they are going to evaluate it. And the way that they're going to evaluate it is based on a standard that seems, again, quite broad and subjective. Where they're looking for kind of anti-American viewpoints. It's not really clear exactly what they mean, although obviously from the students taken into detention, it's clear that anything that's, talks about Palestine is going to be, something that they're screening for. Overall, I think that, this is something that's having, a very significant impact on students that are already here and students considering coming here. Because they are going to have to go under this enhanced vetting or have some concerns about, will I be, detained? There's also a new kind of rule that has been proposed that would make it so that students, rather than having something called duration of status, so that they are in status as long as they're here and attending school, would actually have limits on, their status where it would end and they would have to apply to extend that status. And I think that, looking at a big picture of that, we can think that this is something that they also tried to do in the first administration, where they tried to kind of pass a rule to, again, make it, harder for students to kind of maintain their status, right? So a lot of students, I think, benefit from duration of status because being here as a student, there's a lot of compliance, around that. Students tend to be younger, may not be always as aware of what all the requirements are. And ultimately now with these new changes, students will be in a position where they really need to be on top of every single compliance requirement to ensure that they're not kind of violating their status, or if they, go past their I-94 end date, fall out of status, accrue unlawful presence, are barred from the U.S. So there's, the rule is making it, or looking to make it so that there's just a lot more, even more compliance requirements on students for them to be aware of than there already are.
And I think it's helpful to give people, again, to kind of lift the curtain on what's happening on a daily basis, because, even when I read the news, some of these options, like a student visa, it just seems like it is a path that is next to impossible. Again, if you're looking just at the news, it seems like it's constantly under bombardment. Practically speaking, though, when someone sets up a consultation with you and they say, hey, I'm interested in getting an F-1 visa, a student visa, how do you think about that as a viable path? Do we still see people following that path? How much of an impediment in practice are these changes that the administration is implementing?
Yeah, so I do think that I think it's a good point that the news kind of when if you just read the news, it's going to be kind of an onslaught of all of the worst cases, and what can be challenging in that is sorting out kind of what is kind of normal. Like there's always going to be a certain number of denials or issues, and then kind of what has changed and has gone beyond, what is kind of normal practice. I will say generally, despite everything in the media, the F1 is still a viable visa option. If you are accepted to a university, if you meet all of the requirements for the F1, it is still a viable visa option. It is, I think similar to all other visa types, we're still going to be looking more closely at, okay, any kind of immigration violations in the past, any kind of, issues like having an immigrant petition filed for you, any kind of criminal, touch or issues that you've had in the past, those things will all make it, more challenging, than it would have. That being said, for, an applicant who doesn't have any of those issues and is just seeking to come to the United States to attend a university, the F1 is still a very viable, visa option. It's just you want to do kind of a more rigorous discussion, with your attorney of kind of everything about your background, just to make sure that you're screening for any of these issues that are coming up. Very relevant for students, I think, is the social media. Because they do share so much on social media, and now those will need to be made public. Just deleting them won't always work because you do have to disclose if you had it in the last 5 years. So that is something to keep in mind, and that does need to be discussed, when you're considering getting an F1. That being said, it is still a viable option to get into the United States. It's not that mass numbers are being, denied it's not that it's foreclosed as a possibility, but there's more risk to it.
And what about from the employer's perspective? So in the past, if they were considering hiring a student on OPT, how does that, in your mind, how does that thought process change given the changes over the last 9 months or so? What should employers have in mind now that maybe they didn't necessarily need to think about, say, a year ago?
Yeah, I mean, I think that it's always important for employers to be able to uh, check to make sure that the person has the work authorization, right? So don't just take it on face value that they have the work authorization. Ask, obviously, follow the process for, proper I-9 verification. If they do have, kind of CPT, which is called curricular practical training through their school, just again, making sure that that's annotated on the I-20, that you've gone through your proper, I-9 procedures. So I don't think that kind of so much has changed there, other than that we know, again, we're in an era of enforcement. And so you want to just make sure that every compliance requirement for hiring somebody, like the way you would for anyone, is followed. And knowing that, let's say you have someone going from OPT to STEM OPT, that there are many more compliance requirements for STEM OPT, and making sure that you are aware of those and on top of those, as the transition is made.
Perfect. So, Kelly, I'd like to shift gears a bit and focus now on some visa options, including the O-1 and the EB-1, which we call the extraordinary ability visa options. Just to give a little bit of background, these are visas that are in the minds of the government when these options were created. It really was to encourage people who are leaders in their fields internationally to come to the U.S. So if you are a leader in the arts or a leader in business or a leader in the sciences, then one of these may be a good visa option. And the other thing I'll quickly say is that these options do allow for self-petitioning. There may be steps you need to take to make that work, but in general, they are generally speaking available to those who are entrepreneurs or don't necessarily have an employer sponsor in the U.S. We're not going to get into those details so much in this episode. We do have longer webinars on that, as well as podcast episodes on that. For the purposes of this discussion, Kelly, I'm curious. One of the things we do as lawyers is a prospective client or a client will come to us and say, here's my goal. I want to pursue this endeavor in the U.S. Help me figure out the visa option to get there. Help me make it a reality. So if someone comes to you with that question, how does your thinking about the extraordinary ability visa options, how does your thinking about those options change in the current administration versus a year ago? Do you think about those options any differently given what's going on in immigration currently?
I would say that I don't. I still will consider the full spectrum of visa options that they might be available for and kind of try to prioritize kind of their, their highest goals and how to get there. But so I'd say don't view it differently. I continue to, screen for, do you meet the criteria and can we make a strong case and what's going to get you, where you need to go.
And in terms of those policy changes that you mentioned, specific to, say, the O-1 and the EB-1, could you talk a little bit about those? Whether there's, and both formal and informal, so including any heightened scrutiny, evidence that may be given more or less weight now than it did in the past, than it was given in the past, or even the possibility of requests for evidence. Can you talk about changes in terms of those policies?
Sure. Yeah. So I think that anytime, like if you're in the US, you're doing a change of status, you really want to think really hard about kind of maintenance of status issues. So for example, if you're a student, you're trying to go from F-1 to O-1, those compliance issues I was talking about previously, like have you been going to class? Do you have your proper I-20s? Those are going to be really important. And that's the same for kind of any, kind of change of status that you're doing. We're seeing more requests for kind of biometrics, right? Because they want to then run, kind of fingerprints and see if you have any kind of issues that they haven't flagged before. So you do want to be kind of very attentive to that, whether it's in the O-1 context or whether it's in kind of the EB-1 context. I think in terms of the evidence, objective evidence is pretty much always going to carry the most weight. And things that where if we're in an environment of enhanced vetting and an environment where they're being asked to look at petitions more closely, anything that is kind of more objective, right, is going to be helpful. Things like authorship of scholarly articles, peer review of scholarly publications. If you have a patent, with your name on it, these are things that, can be, arguably kind of more, objective. Obviously you wrote that scholarly article. So I think those, as much as you can with kind of those types of evidence, leaning on those more objective types of evidence, that can be very helpful when you're approaching these types of cases.
One of the questions that has been floating around, particularly regarding the EB-1 green card, is whether it is riskier to apply with premium processing. So premium processing is the option provided by U.S. Citizenship and Immigration Services, USCIS, that basically expedites your application. Kelly, what are you seeing in terms of whether there is any increased risk with premium processing or not? Are you seeing any patterns at all?
I would say this is something that comes up quite a lot in the immigration forum discussions, and it came up, during the first Trump administration, and it came up during the Biden administration, and it's coming up now again. Generally over the years, we have not seen major differences between filing premium processing or not filing premium processing. So I really think, I don't know that it severely heightens your risk. It's not something that we've seen in practice, but I do know practitioners that, do feel that it does heighten the risk. And it certainly could be the case that we tend to focus more on kind of O-1 entrepreneurial cases, kind of business people. It certainly could be the case that people that are primarily doing things like athletes or primarily doing, artists, they may see different trends than we might see. But for us, kind of in the O1 space that we practice in, we have not seen a major difference between premium processing or not.
Great. And we've been talking quite a bit about USCIS. I want to shift a little bit and focus on the consulates. The first question that I want to ask you is, when you read in the news about a policy change that Marco Rubio has announced in his role as the Secretary of State, taking a step back, I know, file applications all around the world at consulates all around the world, including within the U.S. Through USCIS. When an announcement like that comes out from Secretary Rubio, what do you see on the ground? Do you see consulates, uniformly implementing a change? Do you see variation? And then when a client actually shows up at the consulate, how do you see that actual face-to-face interaction between the client and a consular officer be different based on these policy changes?
Yeah, no, it's a great question. So I think that when there are policy changes that are announced and come out, sometimes there is like one or two things that will uniformly happen, right? So most consulates now have language on their website that says, if you are applying for an FMJ, then you will need to, provide your social media accounts. And this is just kind of uniform across consulates. Much more when there is policy changes, consulates are given kind of the freedom to implement them. They have to implement them, but they're not kind of prescribed to all implement them in a uniform way. And being all over the world and having completely different staffing, capacities at various consulates all around the world, they do not implement them in a uniform way. This was the same thing we saw with the pandemic as well. Like visa processing all stopped at the same time, but then the speed at which visa processing came back, the way it came back, which categories were available, timelines, all of that was different across consulates. And I think we are seeing that to an extent with some of these policy changes. So certain things are very clear, right? Consulates, there was a policy change that said consulates can no longer waive, interviews for most applicants, including applicants under 14 and over 79, which was a very long-standing policy. That is now kind of uniformly the case across consulates. That being said, the way that the policies are actually being implemented, when you're face to face with that officer, I think, those are going to be kind of different across consulates. We're also seeing confusion, right? So there was a policy that came out recently that talked about applicants, generally being required or they should apply in their country of residency. This led to a couple of people, getting information from consular officers that they couldn't get their visas issued because they weren't a resident of that country. However, then later that day, the consulate contacted them and said, sorry, we misunderstood, and they issued the visa. So you do see this kind of confusion, on the front lines, because it's going to take a while for so much policy change to really trickle down. And especially when it's not super clear, like that policy change about, third country nationals and where to apply, it's not actually terribly clear what exactly they mean by it. Though that's where you're going to start to see kind of changes between consulates, how they're enforcing it, and it does, create some confusion.
Great. So, Kelly, as we wrap up this episode, I'm curious if you see employers and individuals who want to come to the U.S. to work. How are these changes in policies that we've been talking about causing trends within immigration in terms of what options employers are looking at? Maybe that's a different visa option, or maybe that's using remote international workforces, and options that the individuals themselves are looking at. So if someone might have wanted to come here on an H-1B, say, they would consider a different option. I'm curious if you're seeing any trends in that regard.
So I would say I think there hasn't necessarily been enough time, as you said, to kind of look and see, yes, we have a major, major chilling effect, on kind of legal immigration in the business sector. Obviously, as a business immigration attorney, every day I'm continuing to work with both individuals and, companies that are interested in bringing people over, despite the challenges that have been there. And, for the most part, we are still having kind of many applications be approved, then the process to actually get people to the U.S. can sometimes be trickier because of some of this enhanced vetting, at the consulates. I do think, unfortunately, the overarching, picture, both in the media, and in terms of just the policies that are being implemented, do seem aimed at limiting, legal immigration, and companies, as they, start to experience those difficulties, or individuals as they say, I don't want to risk being detained. I don't want to risk being put into removal proceedings. Certainly, yes, they may start to, look into other options, for work.
Absolutely. There really is a sense of wait and see. And I know you were talking about that in terms of the way consulates are implementing policy changes, where a lot of it is, let's see how it's implemented. I think the other area that has a lot of people concerned, including practitioners, the immigration lawyers, is the notices to appear, and just kind of a cloud of fear regarding whether, in the past you would have been allowed to stay in the U.S. while a petition is being decided, or while you're in a grace period. Now there is oftentimes that question of risk, but Kelly, you do remain available for consultations. And so those of you listening, we're talking about a very complex topic in U.S. immigration. And it's complex in large part because it's changing. And so I just want to emphasize that we are happy to speak over a consultation. Visit our website. It's easy to find a time that works for you. Set up a time. You can choose Kelly to speak with specifically if you'd like, or any of our colleagues if you'd like. Kelly, to wrap things up, for either an employer who's looking to hire a foreign national over the next 12 months, or for that foreign national who's looking to come to the U.S. to work, what would be your words of guidance, words of encouragement, whatever words you would give them to keep in mind over the next 12 months as they're looking at that goal?
Sure. I would say that don't focus just on every single terrible article in the news. While there are many, and there are many things happening, very often, because this is such an important topic right now, there are articles written where they'll talk about, tourists being detained and removed and things like that. And sometimes you're really not getting the full picture. And because there's just more attention to this broadly, there are some cases where, I will, as an immigration attorney, look at it and say, well, yes, I understand what happened here. And it's much more complex than the media is portraying it, obviously because they are not immigration experts and they can't kind of go into the details. That's to say that I think if you do have, concerns, obviously consider those, but then talk to an immigration attorney, talk to someone who can actually kind of demystify for you, what is going on, and kind of separate out kind of the actual changes and what we're seeing versus kind of what's on the news media, which again, brings attention to many important issues, but often lacks important nuance about what's happening in certain areas.
Great. Wonderful words to end on. Kelly, thank you for taking the time to join us and to share your expertise. To our listeners, thank you as always for taking the time to join us. Please do subscribe, leave a review, share this podcast with anyone you think who might be thinking about coming to the U.S. to study, to build a business, to be with their family. Reach out, schedule a consultation. We are always happy to help. In the meantime, stay well. Thank you.
Thank you.